So this week we had Sarah Boone and her official hearing, and it was an interesting one. We had prosecution basically just holding her hand and being nice to her. I don't know if they're really going to change their tune when trial starts and say this terrible woman and this horrible piece of shit, but right now they're really just trying to help her over the finish line. And that is specifically completely because she doesn't understand things, bro. She's in over her head. She tells us and the judge and prosecution that she's in over her head and that she does not want to represent herself. She said it multiple times in this hearing. She's point blank period, just to say it that way. We have the entire hearing right here. I clipped it up from a live stream. And we just, we talk back and forth with the stream. We talk about what we think is going to happen in the future. And it's super interesting. So for those of y'all who haven't seen this, check this out.
First is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions? Yes. Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed...
The judge is either very patient or has a sick sense of humor. I think both. He's having a good time. Like, why would you rush this shit if this is your job? Like, you come to work every day, you judge shit, you see the scum of the earth every single day. Why wouldn't you have a little fun with that shit? You know what I mean? You see, like, she's wasting her life anyway. All you know is that you get to go home, hang out with the family, you know what I mean? Drink your whatever, have a good time with whoever, smoke whatever, and then you come back to work and get shit popping. So I would not be shit. I would be having a good old time behind the stand right now. Like, I would not, even in the Darrell Brooks situation, that's a little bit more infuriating because he ran over kids and women and men and all types of shit. But in terms of Sarah Boone, bruh, I would be the coolest cucumber ever. What do I have to be frustrated about? So yes, to respond to your question, you wonder if it's a sick joke to him. It probably is, and I don't blame him.
Your response, do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. It outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified? Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for prison break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I said earlier, the motions do not identify who the witnesses are or what the components are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date once I have that information to revise them.
I'm giving you the opportunity to refile them. Yes, ma'am.
Thank you.
Hey, what's up, Tanika? How you doing?
With regard to the defendant's motion for reservation of proposed costs to With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense and trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision.
Amy said, I thought she excelled at everything. Listen, this lady, we're going to see this lady crumble in court, okay? You guys think you think a few letters, you know what I mean? You think a few letters makes this lady smart? I read the comment in my video the other day about Sarah Boone, and I just made the simplest comment. I was like, she's smarter than your average moron, like a Daryl Brooks, right? They must have took it in the wrong way. What's up, Nash? They must have took it the wrong way, thinking that I was saying she was smart, because, ladies and gentlemen, she's smarter than your average moron, but she's still an idiot. Like, you know what I'm saying? Like, she's going to fall apart in court. Trust me. She's going to get mad. She's going to get flustered. Midway through court, she's going to shut down, and she's not going to know what to do. She's not, I promise you, she's going to go well for all of 3, 4, 5 minutes. Her opening statement will probably be very good. Opening statement, all that shit, thumbs up. The second it gets to cross-examination and examination, brothers and sisters, it's not going to look pretty.
And whether the requests are appropriate.
Okay. Ma'am, the
What's up, Jesse?
motion fails to identify
Jesse
any
Staines.
specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts. And it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile.
All these motions are getting denied, by the way, if you guys didn't realize. Hey, and Christine, shout you out, man. Shout her out with the euros from across the world, from all over the world, man. Shit, shout her out. I need some fucking sound effects. I need to get a soundboard so I could be like, burr, 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 some shit like that. I don't know. Yeah, she's gonna get shut down every
Lastly, is
every
the
single
defendant's motion
time.
requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024, and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
Watching 2 a.m. in Australia. Shout you out, Jesse. That's some
No,
real
Your Honor,
shit.
other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Yes, briefly, Your Honor. The point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is asserted to represent themselves decides at some point they no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is incenting not to get involved until the defendant says, I no longer want to represent myself.
And then, okay, so this is why they're not going to give her assistant counsel or standby counsel. Did you hear what he said? This is specifically why. She's trying to find another loophole. Sarah thinks she's a brilliant person. My bets are that Sarah knew the definition of assistant counsel. She did know that, but she doesn't want to actually represent herself, right? She doesn't want to represent herself. She knows she's not equipped. She's smart enough to know that, right? So what does she do? She gets standby counsel. Trial begins. She gives her opening statement. She does all the things that she wants to do. She does all the things that the lawyers wouldn't have done for her. And then after that, she'll be like, okay, I don't want to fight my case anymore. Pass it on to assistant counsel. I don't want to do it anymore. Pass it on to assistant counsel. Then therefore she has a lawyer again. So I think she would just do that so she could say a few words, literally day 1, day 2, and then after that, just pass everything off to assistant counsel, which is why they're not going to give her that. They're just not, bro, because they already see that she thinks that she's smarter than the court.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul v. State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel.
Yeah, he's not going to give it to her. Denied. Moving on. Out there
the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepard v. State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
No shit. And then he just looks at her. Kraynick is a fool, low-key, bro. He just reads the shit off and then he kind of looks at her to check her temperature. You know what I mean?
For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
He's like, did you get that? Are you mad? Are you turning red? Okay. All right. Let me get back to it, ma'am.
Do you have any other questions, ma'am, as to the court's rulings this morning?
Would you like to blow up, ma'am? All right. Let me turn her up. I'm going to go into my little OBS settings. I'm going to max it out. Tell me Tell me if it's too loud and I'll turn it back down. But I'm going to max that shit out. Hopefully it helps a little bit.
I do not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So
no shit.
I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period.
It is denied, period. Shout the judge out.
With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order.
Yeah, he's taking no shit. No shit from Sarah. Because he saw how she treated all the other lawyers. Do you know how they go down in history? For whatever history they have, it's not like the world is going to remember the other two judges, or I mean, the other judge or whatever, or the other lawyers, but you just always think back and say like, oh yeah, she took advantage of that judge. And every time you look them up, Sarah Boone is going to pop up. So this judge said, listen here, I'm not finna be made the idiot. That's what he said. He came into this saying, she's not going to make me the fucking idiot. I'm going to do this trial, and I don't care if I got to stay up all night to make sure it happens, which is, I'm sure he had a bunch of sleepless nights to make sure this thing went through. Shit. He was like, I'm not finna be that other judge. That's what he said.
No such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is in regards to competency as opposed to having an understanding before you take someone's rights away.
Ferretta pertains to a criminal defendants seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand.
Who do you think she'll call as witness? She's definitely calling her ex-husband as witness. She's calling her landlord lady as witness. Those are the two that I think she's going to call for sure. Because apparently she thought she was kind of friends with the landlord woman or whatever. She tried to be friends with her. So, yeah, I think she's going to call those two people.
That I was explained most of all of this, and as opposed
But shout you out again, DW. I appreciate that.
to prior, so I would know what happened or could happen. So my understanding is one thing.
Brian Boone is the state's star witness. Damn. That's not good. She's definitely going to cross-examine them.
And then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my rights to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you presently.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order.
That
order
reality
stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that is my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Thank you.
Yeah, see? He's not going for the bullshit. And he sounds like a father kind of disciplining his child. Like, daughter, I respect your opinion, but no. No. He's really sonning her. He's daughtering her right now. And she doesn't like it. But what can she do? This is the only this is God to her. This is her Lord and Savior. He has the right to do whatever he wants with her and her life. So she's got to play nice. She got to play nice to God, because God could smite her down straight to hell, which is what he's pretty much going to do anyway. She missed so many plea deals. I honestly don't think she needs a life. Like, I don't think she needs to stay in jail for the rest of her life, but God damn it, she's kind of going to end up doing some life sentence type shit because of all of this.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th.
Well, we moved on from 2 weeks to 3 weeks. Do I hear 4?
So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pre-trial so that we might be able to have our own pre-trial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
Nah, I think that was the delay that the judge wanted to do. I don't think it has anything to do with Boone. And this is just pre-trial shit. She's not. I don't think she has. She can't delay shit. It's out of her hands. It's out of her hands.
Acceptable to the state.
Through her conduct.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your
she's
position
regretting
is
it
with
now.
regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided
Ian?
to
How you
Ms.
doing?
Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense,
Yeah.
and I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been
That's what I'm saying, Ian.
sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. It would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using.
It is a trench coat?
I don't know what you intend on using.
Wait, it is a trench coat? Oh, it is. Trench coats are heavy-duty wireproof outerwear that can be used for a variety of purposes, rain protection, layering, etc. All right, my boy with the trench coat in that bitch. Don't you ever play with that man.
I don't know what evidence you have.
Thanks again, Janice.
If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
Go ahead, sir.
so I think we could accommodate that if we could go
There's not a hurricane
around
inside.
September the 1st for that, and then that would give her an opportunity to...
I think he might be having a TV moment. But I mean, hey, you know, shit. Wear that trench coat, boy. Shit.
review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay. And that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list in the USB.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
Then we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure.
She's so fucked, bro, because all of these things, like, everything's stacked against her. You'll get to come in and get to view the tangible evidence while we have this hearing, and then you'll go back to using a thumb drive. Fuck me. Just bend me over. Don't, like, shit. At least take me to dinner first. You know what I'm saying? Like, everything about this is fucked, bro. And she literally did that to herself. She could have been looking at 10 years. Time served. What is that? 5 more years. Or at the time, it would have been like, what? 6 more years. Time served. Stupid motherfucker.
Based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality that is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent.
Okay, it's only for that hearing, but that would be some bullshit if they kept the media out. But at the same time, they probably have their official court cameras. So we would probably still get the information after the hearing, I'm hoping. But who knows?
Intimate details of the case being released prior to trying the case.
Understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some...
It's pertinent to this discussion. It's very pertinent. I like that word, pertinent. What does that even mean, pertinent? You know, you say it so many times, it's like, what the fuck does that, like, what are we even saying? They say it so much, it's like, sometimes it loses meaning for me.
Met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media.
Shit. They have autopsy photos too? Oh, shit's gonna get real. I don't really do the autopsy shit. I don't like it's like it's the autopsy shit. But I forgot this case has so much. They have the state. See, we focus on Sarah Boone, but we forget at least I forget what the state has up their sleeves, bro. The autopsy is gonna reveal so much about this shit. Pumpkin Porter, shout you out. Thank you for the 10. Shout out Pumpkin Porter for the 10. Sarah was so foolish not accepting the plea of 10 years. OMG, she could have got 25. She will. Oh, you're saying she could get 25 and she will. Yeah, they're going to max her out, bro. You think the state gives a fuck about her? They're going to max her the fuck out just because. They're going to do it with a smile on their face, too. It's funny that she denied the 15-year plea and got 10 years, and then she denied that like this was a game show. She really thought that shit was like a game show. I'm going to go for broke. I'm going to go for 5 years instead of 10. Stupid ass. Damn, all this info coming at her at once. You know she's got to be scared. Yeah, you ever gone to college first year and you had to pick up your curriculum and shit and you got all the info on the first day courses? Think of that times 3. First day, first class. Shit, she's shitting herself, bro. If she's not shitting herself, her comprehensive level is at a lower state. She needs help mentally. But if she has the mental capacity of a normal person, she's shitting herself.
To the public.
Thanks again, Pumpkin Porter. I appreciate you.
The state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes.
Unintentionally, yep. Lindsay, yep. Unintentionally. We have shit. I should name one of the fucking videos of Sarah Boone unintentional in quotations.
Suggestions, and then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have
that's
the
actually
sign
crazy.
off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything. MC,
this 100% is justice. Go look back at the Darrell Brooks trial. Did they help him? No. Look back at Ronnie O'Neal's trial. Did they help him? No. Look back at what's his name, Baldhead Treehouse Killer. Did they help him? Well, his case was a little bit different. They did help him slightly. Shit. If you forfeit your right to counsel, that is justice. I'm so sorry, but it is what it is. Life ain't fair sometimes.
That is correct.
I'm unclear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the court.
Christy said trench coats are for hiding long guns. Yep. If I see a man with a trench coat on in the summertime, I'm not going to go near him. I'll tell you that much.
So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go with answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, etc., would be addressed here in open court.
And just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or to OPD's evidence center, whichever agency, and they come and view it. But it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever you deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here.
You see what I mean? She's just inherently fucked. If you were a lawyer, you could have just viewed the shit whenever. You probably could have came into court, because it needs to have, apparently there needs to be witnesses there or somebody needs to be there. Whatever the case may be, you can figure it out. But her on the other case, she gets a day, maybe, to look through it. The fuck are you going to do with that? You just look at a bunch of papers and retain nothing? She's fucked, bro. She's getting that fat 25. Imagine that. I could just see the stress radiating off of her, bro. It's when they say you're glowing, she's glowing with stress. You can see it. It's no more fun and games. The little smiles that she always would have, all that shit, that's out the window. Shit got real for her. Shit got really real.
Just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here. And I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that I cannot be transported anywhere other than here?
What's up, CB? You missed a lot.
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record.
Look at her face. No. But look at this, though. You see this face?
What was reviewed.
This is the face of concern, ladies and gentlemen.
Opportunity
for me to rate. That's the face of frustration, concern, fucking all the shit. I was gonna say another word, but I can't remember. Despair. That's the word I was looking for. That's the look of fucking despair right there. You just gotta laugh. You gotta look at this and laugh at it, because in any other world, this trial would have been over with. The story wouldn't have even been that big, bro. The media wouldn't have even latched onto it that hard. When this first happened, I covered this story a long time ago, like when my channel was new, and in my head, I said, oh, this trial is going to be like whatever. I'm going to cover it because she's kind of a crazy lady who locked her boyfriend in a suitcase. Obviously, we're going to cover this and talk about it. It would have died. Now she turned this thing into like a worldwide case. You know what I'm saying? Like, it's hilarious. Anyways.
Make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So,
Oh, she's getting mad. She's getting mad, guys. She's getting mad.
That was already identified by the state is here saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
I know I'm trying to keep up with everything. What was? And then she looks at him. Bitch, you're not going to enjoy playing that game. She's not going to enjoy playing that game, folks. Remember, I said earlier, this is God. This is her God. That is the only thing that matters. That is the God in her sky. You don't want to piss God off because he's just going to strike you down. You don't want to do that.
So,
Yo, what's up, Irish Pastry? How you doing? Shout out to Irish Pastry. Shout out Pumpkin Porter. Orange County has been paying for all her counsel for 4 years now. It's your turn, Sarah. Shit, what is she going to pay with? You know, what is she going to pay with?
an attorney
Prison labor?
who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term, and then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package...
No despair. She's furious at the judge. Oh, she's furious at the judge's audacity. You think so? I think it's a mixture of her being furious and some despair. It's gotta be like, maybe not. Maybe she's just bitching she's just bitching in her head. Maybe it's just all anger. But I think she's gotta be kind of fucking sad about her situation. Like, in hindsight, thinking that you could be 4 years away from fucking freedom, but now you're in here fighting for your fucking life. You're fighting for your life by yourself. You know what I mean? Like, fuck, that would make me kind of go crazy. Think about it. 4 years away to freedom, as opposed to fighting for your goddamn life by yourself, drowning in the ocean. And all the judge does is look at you and says, I can't make that determination, ma'am. That date is set, ma'am. No, ma'am, I'm sorry. The decision is final, ma'am. Shit. That'll make anybody go crazy.
worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding.
Man, Judge, fuck all that. Fuck all that. Let us view it. Let them view it. I'm not going to be there. Let them view it so I could view it because I'd be viewing what they be viewing. Fuck all that. I don't really care if we get to view it or not. I really don't give a fuck, but it would be interesting if they did. The meat and the potatoes are in the actual trial, so I'm cruising until then. She's that arrogant and disconnected. Yeah, it's like, lady, we know everything about you. We probably know, like, her blood type. Somebody on the internet probably knows her blood type at this point. So, like, I don't know what she thinks about the media not knowing certain things, but we probably know more about this trial than she does. And the professional YouTube lawyers and all that shit, they for sure know more than the trial than she does. So I don't know what the fuck she was thinking.
There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent
No. I know we have a right to access certain things, but I think the tangible discovery or whatever could like taint the. And you know how the court has all these little rules, so they're probably gonna keep media out for that, or he's gonna push to have it done. He doesn't even know if he can. That's how. You know, they're in Florida. You know what I mean? The state of fuck it, let the media see. Florida is the definition. When you spell out the word Florida, like it reads out to let the people see it all. They release everything. So honestly, I wouldn't even be surprised if the judge couldn't keep the media away. I think of jail as early retirement. What the fuck? If you get out of jail, what on earth would you possibly do for the next 30 to 40 years after this all? I mean, she could work at McDonald's. You know, she could fuck McDonald's. She could make a YouTube probably. She could survive off social media. She could do. Listen, you could make money doing a few things. Is she smart enough to do that? No, she would probably just rot away and be a drunk. But there's always a chance. Anyways, let's continue.
Media access. So without doing a little bit more further dive of research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing
This hearing was yesterday, none.
has been televised. So,
Wait, what did she say?
Heard of a case where the evidentiary hearing has been televised. So, if you could please look into that, because I disagree with the media being involved in that.
I understand your position.
Yeah,
and
I
again,
doubt she's
for the reasons that I stated earlier, I'm trying to prohibit.
It took me like 5 years of trying to get some type of traction on YouTube. I had a channel. I had 2 channels before the AG Tactical channel. Those went nowhere. And then the AG Tactical channel was named California Gun Owner, and that took like a year to take off. So, and it's something where it's like you just gotta do it and enjoy yourself. You can't just do it and be like, oh, I need to make money and let this replace everything. Like, nah, bro, get 2 jobs at that. You know what I mean? Get a job, live comfortably, and then make some YouTube videos. But I don't see that's discipline, and Sarah doesn't have that.
Prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, the USB drive or the after our viewing here in court, state, is it your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So
I can't read her writing. You know, I had somebody attack me in the comments, and they're like, "Oh, you can't read. Her handwriting is beautiful." I was like, "Bro, the fuck are you talking about? Her handwriting is beautiful. Her handwriting is uniform. I will say that. So if you read one letter from Sarah Boone, if you could just focus and just like read it." You know what I mean? Just read that shit. I had some moments where I was just like tweaking out trying to read that shit. I kid you not. I was like growling at the paper. Anyways, I got through it. I read it. After you read all her letters, they're very uniform and they're very like she writes them the exact same way. So if you could make it through one letter and you could train yourself to read Sarah Boone's handwriting, then it becomes easy. Which I think a lot of YouTubers have because they've read her letters so many times. It's like a teacher grading somebody's homework. You know that person's handwriting, therefore you could kind of just read it. But I disagreed with everybody. Was like, oh, her handwriting's so beautiful. I was like, no, her handwriting is dog shit. Like, my handwriting isn't the prettiest, I will say that, but at least it's legible. Like, any person who knows how to read English can read what I've put down. It's not pretty, but you can read it. Sarah Boone, listen. Her writing is loopy. I don't even know what that means, but I agree. But I agree with you.
In Ms. Boone's court.
Imagine the judge's brain scrambled, bro, because he read all those notes. Scrambled. Sorry for him. Michael Kraynick. We appreciate you, bro. Fucking soldier.
My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I leave it to her when she wants that to happen. We can make arrangements.
Her handwriting peaked in middle
school.
school.
It should not take us
You're
very long
hilarious.
at this point, given the age.
You're fucking hilarious, Pamela. That is a fact. That is some fucking middle school handwriting right there.
This case to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy.
Duplicative. Just normal conversation, you know. There's some duplicative information, you know, just regular conversation for this guy, you know.
And I believe the videos won't be too hard to decide which ones to use. And I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is
Weird how prosecutors are so helpful. You know, they don't want to mistrial either. They want to win and have that win stay. So, you know, if it helps procedure by any means, they'll help you. That's how I see it. They helped Daryl Brooks a whole lot. They hated him, but they helped them a whole lot because, again, they wanted procedure to be proper. So you help the person if they're fucking procedure up, so that when we look back, at least we know procedure was followed properly. Even if you got help from prosecutors, whatever, the judge didn't help, and you know, I guess the prosecutors wanted to help out. There's no negativity in that. You know what I mean?
prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion, if there is a discussion to be had about plea offers. One of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide...
Man, she's aged, bro. She aged, bro. Jail aged her. Like, I'm telling you, a solid 7 years. That's that stress right there. Look at her.
The court in writing the list of the digital evidence that we seek to introduce, and then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that, or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state
She did not look like this when she first went into jail. And I know it's been about 5-6 years, but nah. Nah. She aged past them 5-6 years.
to assemble that. So my thought would be to...
Each day for her was probably like 2 days. It was like a 2-day smack on the face each fucking day. Each day is 2 days. Times 2 it, bitch. Boom. Times 2. Boom. Every fucking day.
To have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the fiscal evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator,
Chief
would
47?
then meet that afternoon
Damn.
at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification.
You know, what is bro doing?
By providing her the USB with all the narrowed down exhibits out of discovery.
He's the guy who's giving her money to defend herself. Oh, like the court appointed money guy person. Got you. That's what jail does to everyone. No sun, unhealthy food, not enough mental stimulation, too much stress, bad sleep, and last but not least, depression. Ray of sunshine, you couldn't have said it fucking better. Think about all those factors. Fuck me. Slap on 3 days instead of 1 day. There's a song. It's like, why do you think there are people in jail in their 30s with gray hairs? And I was like, damn. Shit. And it's true. I've been around a lot of inmates because my dad was like a jail counselor guy. Inmates be having gray hairs, bro. Real shit. I've been around inmates my whole like middle school life into high school. Like reformed inmates, fucked up inmates, people my dad talking to, trying to like counsel or whatever the fuck. Gray hairs. More often than not. 30s.
Are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane,
Okay.
who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that... I don't know if you
Oh, cool.
are...
Ray of sunshine. Sharing some information. I was an inmate at one point. I was wild in my younger years. It was traumatic enough to straighten me out. Well, at least you got straightened out and then get sucked into it. Because I know straight kids go in there and get fucked over and they turn into full-on criminals just because of the atmosphere. You just turn into a fucking... You commit another crime inside of jail and then all of a sudden you're just fucked. Which is why jail is really not that place. It's like... It's more of a survival... Like a survival environment. Either you're good enough to survive or you get lost in the fucking darkness, bro. It's not like, oh, you go in here and you get reformed. No. You either survive and you have the mental capacity to say, hey, I'm not going to do that again, or you just get sucked into it. Jail turns you into a fucking criminal.
But my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know. I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously have worked on the laptop with USB drives that he has furnished himself from bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail.
Shout you out,
I
Ray
do know the
Sunshine.
captain, whom I spoke to the other day regarding my laptop. But I would very much...
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
D. Giovanni?
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my...
I love it when she says, I don't feel comfortable, please. What? And she does this all the time. This is her sentence structure. When she's like telling you how she feels and then adds a please, it's almost like she's telling you how she feels and saying, don't do that, please. I don't feel comfortable, please. Don't do that, please. I don't like that, please. I don't understand, please. Sarah Boone, ladies and gentlemen, Sarah Boone. That's how she speaks. If you notice, she does that please as a passive aggressive little jab. Just a little passive aggression. Just a little tahine, you know, a little passive aggressiveness. Spice of life, you know? She doesn't feel protected, neither did Jorge's family. Yeah. She was apparently a monster to the family too. Imagine the state bringing Jorge's brother up. Imagine her trying to cross-examine Jorge's brother, Jorge's mom. You think they're not going to bring the mom for emotional points? They're for sure bringing Jorge's mom. Boom. We got another family member, bro. They're about to crucify her. 100% crucifixion. New age.
Evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If there's a possibility, please.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right. It's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get them involved with fear of harassment or anything from other...
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing.
You see how he shuts her down with fucking logic? Who? Where are their names? Well, they're sergeants. Okay, where are their names? It's a jail. I'm a judge. We can figure this out. Logic, Sarah. Help me help you. And then the bullshit falls apart. This is going to be her the whole trial. She's going to cower down, go back into her little passive-aggressive shell while she gets hammered the fuck down by prosecution. The whole trial. Then every once in a while, she's going to lash out of her shell. Get mad every once in a while. Get some publicity points. Get a few headlines going. You know what I mean? Get me paid. And then she's going to lose her fucking trial. Just as simple as that. I swear to God.
Which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I have yet to receive anything such as...
Don't worry, I have a copy to give
Your
to you.
YouTube makes so much sense knowing your dad counseled inmates. You know what? I never really thought about that as a correlation, but I would like watching interrogation videos, and I always enjoyed watching how people, you guys know the show Soft White Underbelly? Soft White Underbelly on YouTube, and they just talk to people. I always found that interesting. Maybe it's because of my dad. I don't know. Could be.
This morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process?
It was served by U.S. mail.
It was served by U.S. mail.
Mm-hmm.
Mm-hmm.
Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail.
Shit.
The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records, under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail, so by me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know, if anything, that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections District withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the...
Man, I kind of missed a little bit. I'm not going to back it up because you guys heard it. I missed like I missed like 2 minutes. I'm sure it's just her bitching. I'm kind of mad though. Let's go.
Physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have
But they were having a good day.
in-court examination of the physical evidence, that afternoon there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
Can caveat in that order be unless it hasn't already been done?
Damn, you guys are grilling the fuck out of her. Remember, she's an exceptional mother to her son. She excels in everything she does. From her interrogation. Yo, yeah, her interrogation shows you how much she excels in everything she does. It's a beautiful thing to see. Her interrogation was a thing of beauty. I don't even know why she's in jail right now. They should have exonerated her.
You do it ahead of September?
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place.
Understood.
Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th, and if we need to have a hearing with regard to those objections, My
I'm
thought.
not sure how true this was. You're talking about her calling on her hubby and whatever. I heard it was rumored that her husband was paying her apartment. So her and George, I mean, no hits to George. I mean, Jorge just was there because she probably let him stay there. But apparently they were both living there and he was paying the rent, bro. Remember, I was always like, how the fuck is Sarah living there if she's just an alcoholic shit who doesn't really do anything? There you have it. That's a rumor, though. I think it was somebody in my chat a long time ago who said that, so I'm not sure how true it is. But, yeah, I'm sure he's happy to not have that expense on his hands anymore.
Thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I will be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator and yourself, to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Oh, she's gonna be calling
Can you
him.
spell your last name, please?
J-A-Y. Don't get asked that.
She
And what
gonna
is your affiliation with the state?
I'm the homicide unit chief.
she gonna be calling his ass. What's your number, sir? Give me your number.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes, please.
Then you can do that, and like I said, Mr. J, if you could file that notice,
Yes,
just identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the...
Oh, Veronica said something about his 1,000 a month isn't very much. If that's all she got, I'm assuming she was also on some sort of government assistance too, food stamps, Medi-Cal, etc. Man, if you're like a drunk bum who doesn't do anything, $1,000 could get you by. All you need is booze and rent paid, and you're pretty much solid. You don't even need your phone bill paid. Fuck that. We got YouTube. We got alcohol and YouTube. We don't need our phone to be on. You know what I mean? 1,000 could go a long way. You underestimate her. And this is not California. This is Florida. So how much does rent cost in Florida? It must be beautiful. I would love to. Man, I need to move. I'm gonna leave this state eventually, man. I'm spending so much goddamn money out here. It's crazy. But I digress. Rent's not that expensive out there. You can do a lot with $1,000 now. You can do a lot with 1,000. As a hobo? Not a hobo. But as a drunk piece of shit, $1,000 to go a long way. You ain't got no car bill to worry about. You ain't got no phone bill to worry about. You ain't got no kids to worry about. What you got to worry about? Your Netflix isn't paid. You don't got Netflix to worry about. Your Spotify isn't. You don't got to worry about Spotify. You don't got to worry about food. You don't really buy food. You know what I mean? Because you're an alcoholic. You ain't got to worry about. You good to fucking go. What are you talking about? $1,000 goes a long ass way.
That I have a motion here in regards to, well, I'm in the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So
Brian probably just had 2 jobs.
there's
working his
Great
ass off
restriction
for
also
ungrateful
that
ass
you
fucking
put
lady.
on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence.
What's up, Robin?
because
How you
when
doing?
The laptops are in quote, the laptop is in quotes, closed for the day at 4 p.m. I can therefore pick up using a hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you are aware of what I have already thought of and am trying to.
You hear that please, bro? That please is like a fucking mosquito buzzing around your ears. I just need time, please. It's the most passive aggressive little dig she does ever. She does it as much as possible. The please is not her being respectful. It's her being a bitch. Just if you guys weren't catching that.
Ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I have that to also be looked over.
Okay.
Please. 917, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that would give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I am very weary to make any type of deadline.
Well, we're setting them today.
I understand. So the 3rd is a what day? Thursday?
Tuesday. So the 17th would be 2 weeks later. Tuesday the 17th.
Man, this.
And that is me coming with my objection.
That would be you filing your objections in writing with the court.
You know, the other thing about Sarah Boone, right? The residual information that's going to flood off of her is going to be insane. The trial's going to end, and I am praying. You know how many phone calls she probably has through the public fucking phone records? Listen to me. This is Florida, folks. We're going to get those phone calls. But anyways, I'm jumping the gun. I low-key want it to be over already just so I can get the phone calls. But the time is coming like a train, and she sees it. She can hear the train. The ground is rattling. The fucking particles of dust are starting to jump on the ground, and she sees the light of that train really far away. And she's not ready for it. It's about to run her the fuck over. Time. Tick-tock, baby. September, pre-trial. October, boom. It starts. It begins. Get ready, sweetie.
And to the extent we would need to have a hearing on those objections.
She got no
we would
calls.
have-
Nobody talks to her. LOL. No, she's got calls. If there's anything, there's definitely calls between her and lawyers. You know what I'm saying? Ooh, there's calls between her and lawyers. Come on now. Hold on. Hold the phone. There's calls. If we can get a hold of the phone calls, there's for sure plenty of phone calls with Sarah Boone. Believe me. If it's not loved ones, it's between her and the lawyer. And maybe 7 or 8 of them.
When the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th.
There's got to be a baby guy. You think there's a baby guy who came and got her? Call her up. Hey, baby girl. What are you doing in prison, baby? I know you didn't mean to kill that guy in that suitcase. I love you so much, baby. Probably. I wouldn't put it past him. Just a creepy-ass dude. Just looking for love in prison. Bro, I wouldn't even be surprised if there was a video that dropped or news that dropped that she had a boyfriend. Not even surprised. No, not even surprised. My face wouldn't even change. I'd be like, oh, really? Okay.
Right. What is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Yeah, no. Think of Paul Ferguson as the lowest of the lowest. That's your lowest bar, right? If Paul Ferguson could get himself a girl, anybody can. Paul Ferguson, the twisted body, nasty looking nerd, just all that, just his entire being, right? Repulsive. If he could get a girl, you think Sarah Boone can't get one? You think Wade Wilson can't get one? You have to set him as the bar. And all these people are above him in terms of looks, in terms of personality, in terms of everything. Paul Ferguson, I would say, is the lowest. So, you know, not even surprised.
Forgive me. So today being...
I would be surprised if she didn't have a boyfriend. I'll take it that fucking far. I'd be surprised if she didn't have a pen pal husband or boyfriend or something.
August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
What's up, Monica? I'm
The
glad you
dates
came.
are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial,
Damn.
not including today. And you're going to get your discovery.
Damn, he has it down to the fucking day. You have 62 days, ma'am. Fuck, dude. Damn, the reality is just too reality. It's hitting too hard, bro. I know that made her heart kind of quiver. Y'all, I gotta go to work. Thanks for a great live, AG. Love to the fam. Thank you so much to Jim for the love, man. Shout out to Jim, everybody. Thank you so much for the gifted memberships. Thank you for the love and the support of the gym. I appreciate you. Have a great day. Have a beautiful day at work. Hopefully this video is cut down by this evening for those of you who miss anything. I don't know. It's going to be like 3 hours of a live stream, so you might get this video tomorrow as a breakdown, but who knows? We'll see. All right. Anyways, let's continue. Thank you, Jim. Have a great fucking day.
Today.
Wow.
Yeah, Sarah, I thought this would go on forever too. I really did. I really thought this would go on forever. This is actually about to happen. I believe in Judge Kraynick. Judge Kraynick for president, man. I believe in that man. I believe in that man, folks.
So, wow. So, in over 4 years, it comes down to me representing myself in 62 days?
Yep.
I'm not going to answer that question.
Am I supposed to?
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence.
Damn,
It
she's
sounds
by
like
herself.
Mr. J is going to try to meet with you pretty promptly.
Dead in the
regarding
water.
The digital evidence.
Dead in the fucking water.
So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most, rather, to lodge any objections to the physical evidence.
She's fucked. What are you gonna
I
do?
understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business.
My neighbor has a cat, and the cat has a fucking mustache of fur. So the cat is like white and black. I'm kind of whispering because I don't want them to know I'm talking about their animals. But the face is like white and he has some black across his fucking lip, straight across his lip like a mustache. And every time I go live, the cat comes into the window and looks at me because I guess he could hear me. I fucking love that cat, bro. The cat's so dope. He just sits in the window and checks me out. And he's like, all right. He just left just now. He's like, all right, I got my fill. Yo, it's the coolest. One of these days, I'm gonna put it on my Instagram. Go follow my HE Tactical. I'm gonna take a picture one of these days when he's staring at me. And I'm gonna cut out all the background so it's only the cat. It's a cool ass cat, man. He has a whole ass mustache. It's hilarious. I call him the Mustache Kitty. It's fucking great. I don't even know his name, but that's Mustache Kitty. Anyways.
On September 17th. And those objections will have to be in writing.
I was thinking, yo, Gerda, you literally would. I was thinking about making an emoji of Judge Kraynick. For sure. He needs one. In honor of Judge Kraynick. Put the fucking emoji. You pop up Judge Kraynick when you think of a sensible situation. You put that emoji. You spam the Judge Kraynick. Like, damn. That's a sensible guy right there. Spam the Judge Kraynick. Shit. Oh, shit. Brittany Mercer. It's been a minute since I seen you in the chat. You're coming in hot. You're coming in fucking red. Stop playing with her. Damn, it's been a minute, Brittany. How you been? I appreciate that so much. Just checking in, XO. Big XO back to you, Brittany. Shout out for always being a member, being dope, being awesome. Man, Brittany out here showing love, man. Stop playing with her. I appreciate you, Brittany. Stop playing with her. Nah, it means a lot, Brittany Mercer. And I'm glad you got to stop through. I'm glad you're back. Hey, shout her out, folks, man. She's fucking awesome. Longtime member. Shout her out. Oh, I saw that. I just saw that comment. Only HE Tactical says, have a great fucking day and is sincere. You're funny, Green Eye Bandit. Shit. Everybody shout out Brittany, man. Throw some hearts in there for her. All right, let's get through this. Let's get through this Sarah Boone shit.
If we have to have a
She's about to go bitch about every little thing about it. Watch it.
objections, that hearing will be held on September 26th.
Okay, and if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yay or nay?
I don't know what that means. What do you mean delegated?
I don't know what that means.
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when.
See, you can't get around. You
provided
can't bend his words, bro. Man, he has superior brain function, bro. Because I would even get flustered, but he answers in like 2 responses and it just shuts her down. Damn. What's up, Ann Jacobs? I appreciate you, man. I appreciate that, Ann Jacobs. I appreciate you. I think you're a great person as well. I think you're a great lady. She's screwed? Yeah, she's pretty screwed. She's chopped and screwed, folks. She's fucked up right now. Hey, Janice, thank you again. Shout her out, man. I appreciate that, Janice. Judge Kraynick is done with her bullshit. He's locking her down. No extensions. No more time. No budging on the dates. Yeah. She's trying to start dates, and he always listen. This is the 4th, 5th time he said the dates are what the dates are. You know how disheartening that probably is to Sarah Boone to hear that. Like, ma'am, the dates are what the dates are. Like, listen, it's not penetrating to the understanding. Nah, for real. He's done. He's not going to be made a fool of in history. When they go back and they talk about him, he's not going to be the judge who let Sarah get judge number 3 and lawyer number 10, which I clearly my prediction a few weeks ago was that not weeks, probably like a month or two ago, I said Sarah would have like 10 lawyers before the thing started, and I adamantly believed it. But shout him out. Thank you again, Janice, though. I appreciate that, Janice. Shout out Janice, folks.
Into evidence, be it digital or physical, based on your review of those. The deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date.
She could not have forced him in the suitcase. He had to have climbed in it himself. Yeah, that's the little part of the case I don't understand. A lot of people talk shit to him, but they listen. I wouldn't do it. I don't care how drunk I am. But you know, people do weird shit when they're drunk. So you know, we're never gonna know exactly what happened that night. But people do weird shit when they're drunk.
As of yet, you've asked questions about your motions that I haven't seen yet. Your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable. I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also, if you are proposing that I go to trial within 62 days, that I know what I'm going into and what
How do you talk someone into a suitcase?
So I didn't know if this would just be easier on everyone else if they just delegated the dates and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I don't know. I don't know
what I'm doing. Oh, this is depressing. This is depressingly hilarious.
I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Okay. Wow, she looks sad.
Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. All right. Now, ma'am, I believe that takes care of all of the
judge don't give a fuck.
deadlines with regard to the state's exhibits. Now I want to address deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testify in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and
she's so sad.
That's limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle, please, that I need you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
I highly doubt it.
Documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Whom is it that I need to speak to in order for this?
I am unaware.
We may be to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information. But I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and if also, because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asking? The protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding the
Sure.
USB.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. What I did? No. Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So, understanding that
I don't think she meant to kill him. I really don't. I think she was so drunk she didn't know what the hell was going on. It's sad, but she's going to be found guilty. But I don't know if it's murder. It's probably some second-degree shit. That's why she was gonna get the 10-year plea or the 15-year or whatever. She wasn't gonna get that much because one, they fucked each other up. This was WWE. They were smacking each other down half the fucking time. He was giving her the fucking the flaming elbow, and she was fucking kicking and stomping. Listen, they were fucking each other up, right? So with those circumstances, it's not like, it's not like she was the abusive girlfriend and he was just like cowering in the corner and she just killed him. You know what I mean? So she would have really got the 10 years, bro, but she's too stubborn. She thinks this is like a lottery pick and she could keep spinning the wheel until she gets something that she wants. And then she went bankrupt. Like, she spun the wheel and she got fucking pro se as an answer. And now she's fucked, bro. There's no way around it. She should have. So that's why it was such a light sentence, but like 10 years, whatever. But now she's actually going to probably get 25.
as of right now, you do not have hard copies. You'll be provided digital copies. And to review all this evidence, ma'am, when in time...
And prosecutors aren't going to be nice. They're going to max out whatever the fuck they can max out. They're going to go for, like, whatever's the highest. Because why not? It'll make my record look better. You think prosecutors give a fuck about her? I wouldn't.
Feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce.
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access.
I'm telling you, they're doing some taekwondo in that bitch, Ian.
There's no way that I know how to.
That shit, they were fighting like the Matrix in that shit.
Essentials and fundamental
What's up, Bethany?
equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I would be able to do any of that at this moment. I would like, please, to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone. I don't have access to the internet. You
can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to-be-determined deadline at this time. I understand that there's been some delays with regard to the discovery. As I told you at the last hearing, we're moving as expeditiously as possible.
Wait, what the fuck? How do you know that? She put her son Lucas in the same suitcase. CPS wasn't amused and neither did Brian. I think she planned this. The fuck? Who can confirm that? I have no idea. See, prosecution's gonna do all that. Thank you so much for the 10, Janice. I appreciate that, Janice. Appreciate you. But that is some information. What do you mean she put Lucas in the suitcase? Now, you know, kids, fun. Ha ha ha. Okay. But that's still, given her track record, that's disturbing. I saw that too, Janice. Crazy. Emily said she saw that as well. What the fuck? Thank you so much, Janice. Shout you out. Oh, and we got Light Chaser 2021. Thank you for the 10 as well, man. Showing love out here, man. You guys are awesome, bro. I'm not going to lie. Hi from Light Chaser. Oh, the name. Hi from Light Chaser, who still a she. Rarely catch a live, but also listening, driving, loving the commentary. Much love, AG. Hey, Light Chaser, I appreciate you. Thank you so much for the love. Everybody shout out Light Chaser. I think she put a pic on FB or something. Yes, that's 100% true. What's up, Cassandra May? How you doing? Someone called CPS and they investigated. What the fuck? So she really is on this shit. She really do be on this shit. Yeah, you know, so maybe it came into her head when she already kind of was fucking around with her son, like, oh, we're gonna zip you in the suitcase. She was probably drunk. Imagine Sarah passed out and left her son in the suitcase. You gotta think about all these things, right? So maybe she was playing. Maybe this is her default to when she's drunk. She does stupid shit, and then she's like, oh, let's go play in the suitcase. Let's go. So boom, she's fucked up with her son, puts him in the suitcase, gets called CPS on, allegedly, right? They call CPS on her, allegedly, all allegedly. And then she does the same thing when she's drunk with Jorge. Jorge's a smaller dude. Throws him in there, locks him in there, has a complete freak out, and then passes out. Sounds pretty accurate to me. That's crazy. Nah, that's kind of crazy. Yo, let me shout y'all out again. Light Chaser, thank you so much again. I appreciate the love, man. Light Chaser and Janice, thank you for the information, because that the fuck. So thank you for that information. Let's move forward. I need to look into that. I might make a little 5-minute video on that shit. Fuck it. Put her kid in the suitcase. I'm sure there's some type of CPS document somewhere I could find. Reddit is a eternal pit of information, so I'm sure I could find something through Reddit.
To get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that. Oh, no, I got you. I figured it out, Light Chaser. I think you might have changed your profile picture or something. Because I think last time it was just like a symbol or something. I said something like that last chat. I was like, yeah, shout you out. That laptop with all the information today.
If the defendant's not going to make a suggestion, make a state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trials provided to her. So, for example, the physical evidence.
Hey, Didi. What's up, Didi? How you doing? I appreciate that.
Which we plan on giving
Shout
her
out,
a
Didi,
list
folks.
of those physical items
Welcome
well
in.
in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th. And then 14 or 15 days after whichever day we get the specific list of digital evidence items to her would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence?
Okay, wait. What picture are you guys talking about? Okay, hold on. She made this into a spectacle. Oh, I thought it was spectate. What Jorge's family and kids have to suffer. No, something about a picture. She's trying to get off some kind of technicality. No. Lucas in the suitcase just came to light last week, confirmed by Brian. Apparently, Lucas mentioned it to his teacher. After the suitcase incident with her son, Brian should have filed for full custody, blah, blah, blah. Yeah, well, I mean, he has full custody now. Man, she's so weird. She's like a serial suitcaser.
And 14 days after you've reviewed the physical evidence to provide your exhibit lists.
I don't feel comfortable with any of this.
She posted a picture. Oh, she posted the picture of putting Lucas in the suitcase on Facebook. Wait, what? Hold on. I don't want to put that on the screen because Sarah Boone, suitcase, and Lucas. Sarah Boone puts Lucas in the suitcase. Reddit. Yeah, the depravity of the universe. I'm not seeing anything. What the fuck is that? Oh, it's like a beetle flying around outside. The fuck? Okay, no pictures. Maybe taken down. But good info. There's a whole rabbit hole on Reddit. Oh, and we got 200 likes. Shout out everybody who liked the stream, man. I appreciate you guys. Driving that engagement. All my people. I appreciate y'all.
I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these dates which I may not be able to meet or exceed.
I've seen the pic on another channel. She took a pic of Lucas in a suitcase. Yo, what's up, hello, baby? Hey, send me a screenshot in my DMs, hello, baby. You know where I'm at. AG Tactical 25 on Instagram. Because what the fuck? How come no one's posted that? Do people even know that? Like, obviously, you guys... Okay, so people know about it, kinda. The fuck?
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited, either side, from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party
Yep, or my email for the more formal of people. I mean, I'm like, yeah, DM me on my Instagram. No, email me for the more... Yeah, I need to check my... I'm checking my emails every day as of like 3 days ago. But keeping track of my emails is a problem.
establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to many more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I am stating my good causes now, if not, there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an...
Yeah, who gives the internet fucking prison? Who gives a fucking prisoner or jail inmate fucking internet? Like, who gets... What? Huh? I like how he's not even entertaining the idea. He's like, I don't know, ma'am. you're going to have to ask so-and-so. Just delegate it over to the prison chief. Let him get the headache because I'm not dealing with this headache. Internet. You have files and you have thumb drives. You're cut off. Internet. You'll get internet maybe in prison. Think about prison. When you get nice and situated in prison for 25 years when you could have gotten 10, jump on the internet. Figure out how to get on Facebook. Make a Facebook profile. The fuck? You're not going to get no internet for your court trial. That's reserved for lawyers, ma'am. The lawyers who have the freedom of paralegals and law firms and other lawyers to collaborate with. Those guys, they get internet. Stupid. 10 years, guys. 10 years for a murder. That is the best case scenario. Either that or you get off scot-free. But with all that video evidence, that is the best case scenario for the evidence that she had. Well, Sarah is special. She was a straight A student. She should have internet. That's fucking stupid. What's up, Broken Baker? Yeah, I mean, she's different, right? Yep. She excels at everything, so she should excel at the internet. She should build herself a Starlink or something.
Evidence viewing that we're having with Ms. Boone reviewing the state's exhibits, would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Mr. Boone.
Okay, all right. I will set a deadline for the review of September 26th.
Thank you.
Is the review that you're seeking now, please, for my exhibits and witness list?
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get.
Yeah, 10 years was a sweetheart deal, and prosecution isn't going to go easy on her. Just for the fact that she's been wasting this much time for this long, they're not going to go easy. When sentencing comes for Sarah Boone, that's going to be the day. You're going to see her fall out. You want to see a lady fall out? Tune in at the Sarah Boone sentencing.
And that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness.
Yeah, she'll probably get 2-5.
Provide that to the court in writing by September 17th.
Yes. And if I may ask, please, what you're typing, is that for an order or for today's proceedings?
It is for an order, which you will be given a copy of. It may not be able to be hand-delivered to you, ma'am, because I'm going to have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Hey, could one of the mods put Lisa, there you go. Boom, bam. Thank you, ma'am. Check out Lisa. She just posted my email, Jen.
Other than what I have made known to the court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here.
Your Honor.
All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in. You can stay to the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk's going to go ahead and swear you in.
Swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth,
All right, sir, good morning. Could you state your name for the record?
Sergeant Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown port holding, BRC courts, medical.
No, Lori, she can't take that deal at all. That ship has sailed. That ship is halfway across the Pacific Ocean.
Security and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir? Sir, good morning. Could you raise your right hand? Madam Clerk's going to swear you in.
You swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane.
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right,
They could talk about plea deals, but they're not going to give her one. Why would they give her a plea deal? We worked all this time to go to trial. The trial's like less than 2 months. There's no plea deal. No plea deal is happening.
sir, last time I saw you, I had tasked you with digitizing 2 banker's boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those. This drive here is a copy of all digital discovery that I have in my possession from Ms. Boone for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've made had previously by virtue of being the investigator.
Yes, sir.
Okay.
Hey, he just got a pump. Yeah, he just got a sick pump. That's why his jacket is so tight. Leave that man alone. He just got back from the gym. Leave that man alone. He's deadly. He's deadly.
All right, the record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So, Sergeant Casey, if you could please take custody of those 2 thumb
Damn,
drives.
that's a tight-ass jacket.
And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop and be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you could proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain DiGiovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved?
I'll inform her.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 bankers boxes. Did you bring those back with you, sir?
Yes, sir.
Okay, could you bring those back up?
Yeah, they're going to negotiate with her, but they're not going to give her any fucking deals. You have to negotiate. For example, if she had defense, they would try to negotiate a plea deal. It doesn't mean that the prosecution is going to give them one. Prosecution is not going to give her a plea deal. Because why would they? This is a slam dunk case against a fucking helpless person. You know? This is like boxing. A man fighting a fucking a child. You know what I'm saying? Like, they're gonna win. Why would they give her a plea deal? So yeah, no, they're gonna have talks about it. You know what I'm saying? And nothing's gonna fucking happen. They're not gonna give her anything. They're gonna give a crazy fucking lady who wasted 5 years of the court time a plea deal because she wanted one. Okay.
do see it looks like the original exhibit tags are
Have
still
a great
on
day,
top of those.
Kathy.
Mr. Lane, did you complete and copy everything that was in both of those boxes?
Yes, sir.
Okay, I'm going to have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor, thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or the beginning of next week.
Thank you.
Uh-oh. Uh-oh. The fuck happened?
Okay.
Is it okay if I...
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah, if Mr. Lane, and Your Honor, in light of this, maybe it might be more appropriate for the court to go up to $10,000 for the investigator, because it sounds like he's already done a lot of work, so it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have some more to say about that, but based on what he's already done, I suspect he's probably used up a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses since I'm out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC if that's acceptable.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, say, $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need an order for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, so I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lake, thank you so much, sir.
Yes, sir.
All right.
Judge Kraynick,
Yes, ma'am.
forgive me. What is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing of. I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor. Thank you.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from
He will be
the site
there.
also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning.
Yes, please.
All right, if you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you, it was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order, and like I
Does she ever not have a question? Fuck, listen.
said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document proposing the
Light
dates
chaser.
for today's.
Man, shut up. Shout out Light Chaser. TY Roll with OCOV just got a gifted membership. That was random and perfect timing. I appreciate you, Light Chaser, so much. Gifted memberships. Hello, baby. Lori Griffith got that as well. Mandy, Amy, all those people who got the gifted membership, man. Shout out, Lori. I don't know why I said, you know why? It's Light Chaser. So I said Lori Lightfoot. Light. I'm doing too many cases. Shout out Light Chaser, man. I appreciate you, Light Chaser. Welcome to all the new members, man. We got 10 today. 10 new members. Shout all you new members out. Check out the new perks, the emojis, all the extra videos that are members only. Have a great time, man. I appreciate y'all. More to come. We're about to, man, this month is about to crank up. It's about to gear up, folks. The phone calls with Wade Wilson is about to go crazy. It's a lot of shit happening, folks.
Hearing. And I guess it was some type of notice.
I appreciate that, Lori.
That's what that she was going to print out to give to me, so I have that.
Okay.
Damn, I'm sorry, Vanessa. You just gotta stick around, you know? It's randomized. Gifted memberships are just randomized. That's how YouTube does it.
Mary.
I did not receive that, nor did I receive this protocol list.
As to everything that was being discussed, can you print out a copy of it?
Oh, and shout out Gerda. Thank you so much, Gerda, for the love. Who got that? Beautiful Waterfall got that shit. I appreciate you, Gerda, for the love. Thank you.
It should be in the court file.
All the way from South Africa.
All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
P.O. box as opposed to legal mail, that's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail.
Past this boring shit.
Parenthesis S.
Court day for that motion. Okay. Stand hard
copy. And you have nowhere to store anything. You have a small drawer to keep personal effects. No problem. That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory. You have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I've never...
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the, your motion
Shit,
for...
I appreciate that, Lori Griffith. Hell yeah, you've been writing for a while then. Shit, because I put a couple of them out. I put a lot out. Upwards of 500, man. We're out here grinding, dropping them videos.
Freedom of movement.
I appreciate you.
Well, I'll notice the sheriff, and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me
yeah,
they have no place
Wilson
to
calls
store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you when you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by Sergeant.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus had the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference. So I
Help me understand, please. Oh my God.
know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding, that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited, restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me in prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag, or property bag, that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers' boxes. Ms. Barrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created.
That makes sense.
They are aware it's 2 bankers' boxes. They're aware of what the information is.
He gave her what she wants, now she's freaking out? Pretty much. Pretty fucking much. Thank you for the 4 months, Mistress Cat. Shout her out. Hey, G. I'm so entertained watching her words be thrown back at her. It's hilarious. I mean, it's poetry at this point.
Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs. I was never asked anything. Just like my letters to you prior to you forfeiting my right to counsel, I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week.
Okay.
So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So, if the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
Ma'am, mean, I would entertain an or tennis motion to have it released from evidence. The concern as, and Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver, and I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those 2 banker's boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those 2 banker's boxes because of A, storage, and B, because of the hazard. Now, if the jail's in a position to revise that by virtue of Ms. Boone identifying...
Oh, damn, I'm sorry about that, Bandit. Shout you out for 10 months. And, hey, we're going to be tuning in all week, so come on back. I'm sorry about that. I know you told me some things in the past, but, you know what I mean? I'm sorry, yeah. I'm sorry that happened. We're here for you.
A property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So
Same.
If she moves Oritenis to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th we can revisit this when the captain's back.
I think I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And
Okay, so they're just worried about discovery, how they're going to get it to her.
your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, what's that date, please?
That is the 9th, ma'am.
We're available, Your Honor.
Okay, Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me, just please, one moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order.
That's funny.
that would-
Hello, baby. They don't even check with her. They know she's always available. Facts. You're like, would that work for you, State? Good? Sarah Boone, you understand, right? Bitch, you don't have no say. You understand what's happening, right? Okay, good. Thumbs up. You always available at any time. If it's 3 a.m., you available.
Prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, you're representing yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidentiary, the physical evidence, that I might be able to utilize that?
So my understanding is there was an imaging done of your phone with software called Cellbrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that.
Sarah in these copies, yeah. This is just her way of trying to stall things. But like the judge said, I think he got it through her brain. We're not stalling, so the dates are what the dates are. So if we don't get to where we need to go in this meeting, best believe we're still pushing forward. This is like a train that cannot stop. We're going to have this trial. And I support it 100%.
Giving you legal advice or suggesting that he is the person to hire. I know that defense attorneys in this area hire somebody named Richard Connor, Connor, and then that will be between you and the JAC and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him, with us being present if we wanted to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, a legal expert that can give me a mirror download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at.
She wants her phone so she can prove Jorge was drunk a lot, but she wasn't. I mean, she was always, man, listen, that's not going to do shit. Hey, thank you for the 7 months of being a member. Hey, all the members who be re-ing up and shit, I appreciate you guys, man. For real, for real. Jonathan Cooper, recognize that name. 7-month-long member. Shout out Jonathan Cooper. 10-month-long member, Green-Eyed Bandit. Shout her out. 4-month-long member, Mistress Cat. Come on now, it just keeps going. You guys are fucking lit, guys. Like, for real. You guys are dope as fuck. I'm going all the way up. Who else? Thank you, AG Mods and family. Hey, thank you, Green Eye Bandit. We appreciate. Hey, we're here for you. You know, shit. That's why I try to keep things lighthearted, even though it's some fucked up stuff. I like to watch people's behavior and stuff, and you know, it's a good time. But I try to keep my people entertained. But yeah, no, we here, man. I appreciate you for stopping by all the time. You're almost at the 12 months. It's going to be lit. But nah, we love you.
My phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all of that information should have been downloaded, and I'm not sure
Hey,
what...
Tony, what's up? Hi, G. Love watching you from Australia. Man, shout out my Australians. There's a few of y'all in here, too. My Australians, my Irish people, my folks from the UK, everybody.
Has been provided to you, but
my Africans. Can't forget my Africans now. 3 months, 18 days here. Diet Pepsi. Come on now. Hell yeah.
Double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline, but there is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence, because like you said, there's so much of it would be not relevant.
What's up, girly girl? How you
So
doing?
you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations, is all that information.
See, she wants to know, oh, so you've gone through the phone already? So even if I delete something, you would know? Please?
Should be there. And it's typically presented in two different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
I'm working on my PhD thesis while listening to this. Hey, not bad. That's a nice little combo. A little legal speak, a little legal shenanigans while studying for your PhD. Crazy.
Just as clarification from the court perspective, is that
Sarah does show remarkable attention. Yeah, she shows attention to the things that make sense to her, I feel like yeah, when it suits her, I agree.
that's something that would have been provided in discovery to prior counsel?
Shit, I'm pausing right now. We're at the end of the video. That's why I'm kind of pausing my ass off right now. Hi, G. So glad to catch you live. I've been waiting for this Boone case for years. Right, Aaron? I remember the arrest. I know she was guilty from the beginning. We were playing hide and seek last night, officer. Yeah, type shit. Right? And they probably were in some shape or form. Honestly. And then she got shit-fucked drunk, passed out after brutalizing the suitcase. And they said there was a bat around. They said she had a history of putting her kid in a suitcase. Just a whole bunch of weird shit. It's like she was a ticking time bomb. She was going to hurt or kill somebody eventually. And I wish it was more of a situation where she just hurt Jorge very seriously, and then he was able to testify against her, and then she would get put in jail. Maybe she could change her life, blah, 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 blah. But it ended in the situation where bro just suffocated and died. The worst way it could have ended. Worst way it could have ended. Some bullshit. Because I don't think she's a demon at the end of the day. I don't think she's just a monstrous person, but she was doing some dumbass shit. And maybe a few years in the slammer would have did her good. Maybe she asphyxiated him and he got out and he pressed charges. She got sent to jail for a couple of years, 2, 3, 4 years, whatever. Things could have went better, but again, worst outcome possible.
Counsels?
Yes.
Okay. Then, ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you, and to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior. So this would be
She is a mean
milestone,
drunk.
an epic milestone for me to be able to finally do that. So now, if I don't have what I need or I'm looking for, how do I go about? I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy mirror download of my phone. If it could be brought to you for physical.
He just told this dense-brained, smooth-head cave woman that they used the app, the software, or whatever software they used to take everything off the phone. Took the images, took the text messages. What are we talking about?
With the other physical.
So again, that is going to be something that requires an expert. And then if you get a defense expert and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image.
Oh, so she can't have it unless she works with an expert. I didn't get that part. Okay.
And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, we're going to make sure that that is provided.
Okay. So
Okay.
that is not able to be included in the other physical evidence that you all are supplying.
No, what I'm saying is there's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to as the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program, and all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before. Just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence of me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because
Okay.
it needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of the phone.
Thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
One moment, please. Okay, so everyone is aware that I'm in the process of trying to talk to the captain.
All right, lady.
The only possibility, you
Brent.
know of something through the clerk's website. Do you have a general time frame of when you actually know of something? Because you already had my address correction, but I don't believe updated.
It's been updated
No,
now.
I mean on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or am able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled,
Damn, she is a tiring ass motherfucker, isn't she? Holy fuck.
well, please make sure that I'm included in the certificate of service or portal or whatever it is I might be attached to in order to receive notices to be properly prepared.
Notices have been sent, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
I'm grateful. Thank you.
Yes, ma'am. Thank you.
Goddamn. Sarah Boone, ladies and gentlemen. Shit. That was crazy. That was crazy, bro. That was crazy. Yeah, shit. Hey, keep an eye out for the Wade Wilson video. I'm going to drop it in about 5 minutes. So don't you fucking miss it. Well, actually, no. I'm going to wait till 12:30. So I'm going to drop it at 12:30. Wade Wilson, phone call, all new. Check it out. It's about to be crazy. But Sarah Boone, it's going to be a wild trial. She's going to be a wild woman, folks. She's going to be more passive-aggressive than anything. I don't think we're ever going to see her get aggressive. She might get aggressive maybe once or twice. But I see mainly passive aggression coming from Mrs. Boonage Tunage.